Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us my law partner David Nachman. David, welcome.
Thanks so much, Michael. Pleasure to be here with you, of course.
Thank you for coming on this program, and people are very happy listening to you and me, all the important information we give them every week.
Of course.
So here's the hard question again, the DACA and the DAPA. You know, the Ninth Circuit in New Orleans, I think, they had
Fifth Circuit.
Fifth Circuit,
Yeah.
I'm sorry. Fifth Circuit in New Orleans made a decision about issued an injunction because President Obama had announced and they were supposed to go these programs this week probably.
Right.
But they issued an injunction. Injunction means like a stay order.
Judge Hayman, yeah.
That you cannot do that until we make a decision on this case.
Correct, yeah.
So that is a frozen kind of thing. But I recently got the information that now they have a hearing on the 10th of July.
That's right.
On the same case. Now that's on the merits probably. So
right.
What are your thoughts? Anything can happen from that hearing?
Well, Michael, as you and I discussed, it's kind of interesting what the, playing out what the options are after the determination was made recently. Unfortunately, about a week and a half ago, we got the unfortunate news that the restraints, which were trying to be dissolved, were unfortunately not dissolved by the U.S. by the federal government. So, what position are we left in? Well, we're left with the possibility of, I guess, number one, asking for an en banc hearing in Texas.
What's
en banc means that it has to be a majority of the judges have to make the determination.
So these were only two judges who ordered the injunction.
There were three. Well, actually, remember, it was Judge Hayman who ordered the injunction, and then when it was taken to the Fifth Circuit, it was three judges. Two judges concurred in not dissolving the restraints. One judge dissented. And
en banc means when all the three judges agree.
Have to agree. It's not right, exactly.
But now, two are against anyway.
Right, but
it could be more than three there. Yeah.
So that's one way in which it can go, but I don't know that there's any value in doing that, and I think that generally speaking, I think that if you look to the individuals who are doing the judicial strategy, they also are sort of agreeing in that realm. Also, there was some discussion about the possibility of bringing it to the Supreme Court, and also there was the possibility of bringing it not to the Supreme Court, but just to one particular judge at the Supreme Court who's responsible for possibly partitioning the case in such a way that 25 states, who are obviously making the complaint can act in a certain way, which would be that the injunction would obviously apply to them, but it wouldn't apply to the other 25 states. So that's where we are right now. I think the interesting thing is that the merits will be heard. There will be an argument on the merits on July 10th. That seems to be the date. And that will be really the government's second bite at the apple with an opportunity to dissolve the restraint.
So if the hearing time, judges kind of change their mind, that looks like a good case, they could go back to the injunction issue?
Well, the idea would be hopefully that if the argument is on the merits on July 10th, then that would
dispose the case.
That would hopefully it would be a nice present for the summer to be able to see the new DACA and the DAPA program go into effect. However, unfortunately, there's a tremendous amount of politics involved here, and unfortunately, it's very difficult for us, for anyone really, to guess what's going to happen. Now, one of the things we did decide, you and I discussed, is that to avoid the whole situation, we could go with a proposed rulemaking, which is sort of the way that, as you're aware, the same way that the May 26th ruling, and again, this was a rule that came into effect that allowed H-4 dependents to be able to get employment authorization documents. There was a challenge that was made where an injunction was filed saying that they should not allow individuals who have H-4s to be able to get employment authorization documents.
But this could backfire also, the rulemaking.
Yes, exactly. Well, let me explain the background on it, is that that was part of the rulemaking process, and then what they did was they said, well, maybe to get around the whole DAPA-DACA problem, which again, DACA is prosecutorial discretion, what they would do is submit a rule. And Michael, as you rightfully point out, the problem there is that what you're doing is you're submitting for rulemaking something that's prosecutorial discretion, and as we know, in the past, we've never done that before. So are we opening the floodgates?
Exactly.
And
Pandora's box,
yeah,
as we say.
Yeah, are we putting something into a rulemaking process that should never be there? And that's, I think, what is very difficult, and it's very difficult for the people who are trying to figure out the best strategy, what to do here. So we're really sort of in a holding pattern until the arguments on July 10th to try to figure out where this is going to go. But again, we continue to be cautiously optimistic. We are helping our clients to put together their cases, and it's our hope and dream, of course, that DAPA and the new DACA do become a reality. And I think that on a regular basis, Michael, we're meeting with clients who, after looking at all of their options, DAPA is such a great option for them. It's so frustrating that this is on hold, because this potential benefit really could help out so many people.
So here's a story. I just read a small article in the New York Times today only, and a couple of articles. One says that the way it is going in the court cases, maybe go to Supreme Court or not, maybe these people take a long time. By that time, probably President Obama may even be out next year, 2016. So if that being the case, what can Obama do? They say a plan C. Now, what is the plan C? Number one, that DACA 1, which is not affected by this court case, he should implement very aggressively and try to complete as much as they can and do advertising for more people who haven't applied all that. So put some force in the implementation of the DACA 1, that's okay, that's clear still. Somebody that has not done it can even do today.
Exactly, and they've been continuing to do that on a regular basis. I mean, I think that the administration is making it more prominent that this benefit is available.
The second, in Plan C, second item is that so far, President Obama has been very aggressive until recently in deportation of the people. So now he should definitely try not to do that. As a matter of fact, that the plan they have is priority plan that also says how the ICE officers should do. They should be lenient in not deporting people where they don't have to. That plan should be aggressively again implemented so that the less number of people are deported. And the third part of it is also connected with this, because when they arrest people, they put in them immigration detention. And detention, hundreds of thousands of people are detained, even because of the violation of the immigration laws. It costs government millions of dollars. So they should be lenient, even if those cases, maybe those who are not really coming in the priority, some small crime maybe there or other reasons maybe there, they are apprehended. Instead of detaining them, they should be more lenient. They can put bracelets, they should
anklets,
put anchors.
yeah.
So there are means by which we can go to President Obama's plan number 3, or plan C, you can say. But this will be helpful to a lot of people, so that people don't have to worry until whatever happens, the law passes, not passes. Of course, some people are even concerned about the DACA, where they think that if it is only injunction removed, the case continues, and we apply for this. They open it up.
Right.
They are worried that come 2016, if the Congress is Republican, the President is Republican, they can undo that. Now, that is something for some people to concern about. So the ideal thing would be what you said: dispose the whole case off, finish it off, so that people, their open mind can
right. Obviously, that's the perfect world. But Michael, it's really interesting that you bring up this concept of the deporter in chief, which is what they refer to Obama as. Right. And I was always of the opinion that what was really going on was that President Obama knew that in order to pass a law, he needed to take a very extreme, he needed to take an extreme position on the other side. And if you take a look at, obviously, all of the immigration reform laws that have been proposed in the past, there was always a focus on internal enforcement.
Right.
And it was my feeling that what the president was doing is kowtowing to the GOP by trying to deport as many people as he possibly could. And that was part of the political strategy. Unfortunately, it looks like they felt he wasn't doing enough. Yeah. And so things did not, unfortunately, go the way that he wanted. But still, if you take a look at all of the small bills that are coming out of the House of Representatives, the focus on all of those small bills is still the security of the United States and the focus on internal enforcement. So
that thing failed. He thought that by deporting more and more people, he'll be able to satisfy the Republicans and they will help in passing the CIR. Did not happen. Exactly. It's not going to happen. They are completely anti-immigrants, nothing at all until President Obama is there.
Well, it's right. And that's why I think I agree 100% with what you're saying, is that maybe leniency at this point is what he needs to do.
Exactly.
Because maybe if they all of a sudden, if the GOP starts to see leniency, they'll say, oh, okay, we got the message. Maybe what we need to do is to give a little, because they haven't given anything. So maybe that's what needs to happen.
So Plan C is a good plan. But I mean,
it could be,
this is not making any rule or law. That is purely administrative thing to prioritize. I don't think that even if they go to court to challenge that, court is going to say he's prioritizing because they have to first pay attention to the criminals first, to the terrorists. That is correct.
Right.
So the other people come later on. He's not saying don't deport anybody.
Right.
He says prioritize.
Exactly.
Right.
Exactly.
So that will help a lot of people.
And actually, Michael, speaking of priorities and prioritizing, one of the things, obviously, in our recent video that we posted on our website at www.visaserve.com and also on our YouTube channel, we also talk about what I call the good, the bad, and the ugly of the recent immigration rulings. So obviously, this is the bad. You know, this whole thing with the Fifth Circuit is relatively bad. The good, though, the good news is that coming out of the president's announcements for immigration executive actions in November are some really, what we saw on the administrative agenda, the rulemaking agendas for the USCIS and for the Department of Labor. The USCIS announced that they're going to be working on a rule that deals with parole-in-place for entrepreneurs and individuals who are job creators in the United States. So while they haven't given specific metrics, they are definitely starting to work on a rule, so that was very exciting. The other thing that we started to see is that they want to deal with the possibility of individuals who are in this AC-21 period of time where an I-140 has been approved, that they can apply for work authorization. So that's very exciting, because even though, especially for all of our, for many of our viewers, the many thousands of our viewers who are in retrogression, who are backlogged, they may have an opportunity to get employment authorization documents before having to file their adjustment of status applications. So we're trying to figure out how the government is going to deal with that. So that's another, but it's very exciting to see that the announcements that were made in November are starting to take shape. And even more so, the Department of Labor has announced that they're going to be modernizing the PERM process, which includes making the advertising methodologies and recruitment methodologies more up to speed with what's really going on. So I think that's very exciting. So he has to pay
more attention to what else can he do with administrative processing. Basically, as you said, those people have went through the labor certification, they got an I-140 approved, they are just waiting in the line for the visa number to become available. And India especially has a problem. We talked about last time in the program that Indian quota has a big problem as compared to other countries. So sometimes they are waiting another 4 or 5 years more to wait until they can 485. So this is an administrative action, probably, that he can say, okay, at least these people, while they are waiting in the line, can be given permission to work. But, or maybe they can apply for adjustment of status and permission to work, but now hold the cases. Probably that's what they will do. File the 485, ask for the permission to work, but they will not be adjudicated until the visa number becomes available. And that's a good idea. You know, the H4 was one of them, the employment of the spouses.
Right.
So this, like that, he can come up with another. And we talked about that in one previous program about the per country quota. But that probably would need the legislature or probably
formal rulemaking process.
Formal rule,
Yeah,
but that's okay.
exactly.
It may see some people, even Republicans, are not much against the legal immigration. Because you have these big companies, Microsoft and Boeing and big companies. They want to accommodate their employees to be able to work and continue to work and get their status as soon as possible. So
I think we're running short on time, Michael, but I think we'll be back next week and we'll be able to continue our discussion about what's going on in the immigration world.
Inshallah, everything will work out. So we'll be back next week and we'll give you the more latest information and a number of things we have on our mind to talk about, which we do in our next program. Thank you very much, David, for coming on the program.
Thanks so much, Michael.
And thank all of you for watching the program. Please keep watching us every Saturday and Sunday around 11:40 a.m. Thank you and goodbye.